Hey there, I'm estate planning attorney Paul Ramblay, and in this video we're going to talk about the power of attorney powers that some people question whether they want to grant. So first of all, let's talk about what a power of attorney is. A power of attorney is typically a component of an estate plan which allows you to document who you'd want making your future financial healthcare decisions if at some point during the rest of your lifetime you get to a point where you can't make your own decisions. You can't sign your name, a distribution needs to be taken from your IRA, you're not able to sign to take it. So with a power of attorney, you can appoint who you want to be what's called your agent, to have that authority to act on your behalf. Most married people appoint their spouse as their first agent, perhaps an adult child as the backup or contingent agent. Powers of attorney can be effective immediately when you sign them, or they can spring into effect upon your disability or being rendered incapable. So the concern, though, is when most people hire an attorney to create an estate plan, most of the discussion in the planning phases, in the discussion, focuses on all of the terms of the will or the trust. Things like who's going to inherit, who's going to be included, who's not going to be included, how are you going to take care of your spouse? Do your children or grandchildren inherit in a lump sum? Do they inherit in a trust? And if so, who's the trustee? What are the trust terms? Who's the executor of your will? Who's the trustee of your trust? And also, a component in virtually every estate planning discussion is who you want to appoint as the agent on your power of attorney. But rarely, because so much is discussed in an estate planning meeting regarding the inheritance, rarely does the attorney and the client dive into the specific powers being granted under a power of attorney. So a power of attorney is typically, used so that if you become incapacitated, someone can take your power of attorney, whoever it was that you designated as your agent, they can take your power of attorney to your bank, get authorization to sign on your account so they can pay your bills. They can typically, with your power of attorney, they can file your tax returns, maybe even make healthcare decisions or go access your medical records that are necessary. But what I want to go over is some of the powers when people do take a deep dive into these powers of attorney. Some people question, do I really want to give my agent this particular power? Let's talk about what some of those are. Sometimes people question language in a power of attorney that gives their agent the authorization to take loans out on your behalf, whether that's a line of credit, a home equity line of credit, or a second mortgage, or get a bunch of new credit cards in your name. Some people say, well, Paul, geez, I've worked really hard to be debt-free. I can't envision a circumstance where I would want my agent to be able to take out loans on my behalf. I'm not sure about that. Another one is, do you want your agent to have the ability to make loans to people? Do you want them to be able to make loans to your agent or to other family members? Again, many people say, no, I don't really believe in making loans to family members. That always causes some friction. I don't want my agent having the ability to make loans to people. And then some people question language in a power of attorney where you give your agent the authority to buy high-risk assets like stock options. People will tell me, they say, Paul, I've never bought options in my life. I'm old, I'm conservative. No way would I want my agent having the right to purchase, buy and sell options. That scares me to put that in my power of attorney. Some people don't want their agent to have the ability to sell their home. Some people feel like, boy, I don't want my agent to sell my house from under me and kick me out and put me in a nursing home. Some people don't like their agent having the authority to sell highly appreciated assets. The thought might be, well, look, I've been sitting on this appreciated stock or this appreciated property for decades. I never want it sold because I want my heirs to get the benefit from the step up in basis where all of that appreciation will go untaxed. I'm a little reluctant to give my agent the authority to sell appreciated assets because it may cause a bunch of unnecessary capital gains tax to be due. And another one that concerns people is when you give your agent the authority to make gifts to others or to the agent themselves in your power of attorney. So, some people will say, Paul, I don't want my agent being able to make a gift of $100,000 of my money to someone or to the agent. Now, I will say sometimes when the authority to make gifts is in a power of attorney, that power to make gifts is limited to the federal annual gift tax exclusion, which for 2025 and 2026 is $19,000. But really, that's becoming irrelevant because in 2026, we'll have a $15 million estate tax exclusion. So it's really not necessary for most people to make gifts in order to gain some tax advantage. Because as long as you have less than a $15 million estate when you die, there's no need to get assets out of your estate before you pass away. And then some people get reluctant when they see language in their power of attorney that permits their agent to change their beneficiaries on IRAs and life insurance. Now, I will tell you, the person that you name as your agent on your power of attorney, they can't change your will, but many powers of attorney give that agent the authority to change beneficiary designations on IRAs and life insurance. And quite frankly, there's many people out there who have, let's say, a $3 million estate and $2 million of it is in their IRA. So the IRA, which goes by beneficiary designation, is the biggest asset. So you got to be careful if you're going to give someone the power to change your beneficiary designations on your IRA or life insurance or some other non-probate asset that goes by beneficiary designation. So one other thing I wanted to mention, that some people, are funny about whether they'd want their agent to be compensated for the work that they'd have to perform as the agent under your power of attorney. It's maybe a 50-50 issue. Some people say, no, I appointed my oldest son. He's responsible. He does fine on his own. There's no need for my agent to be compensated if they have to use my power of attorney to transact for me. And other people say, yes, it's not going to be an easy job. My power of attorney agent is going to have lots to do and bills to pay and stuff to keep track of if I can't handle this for myself. So I would want them compensated. And then if they are eligible for compensation, how is that compensation to be determined? So those are all power of attorney issues that you may need to address on the front end. So why are generally people reluctant to grant certain powers and a power of attorney? And I think there's a couple of reasons. One is the fear of misuse. And maybe you do have a responsible daughter that you will want to appoint as your agent on your power of attorney, but you may fear that your daughter's influential husband may influence your daughter into doing things that your daughter would not have done had your daughter not been influenced by her husband. So there's that fear of misuse. And yes, there's this underlying responsibility that your agent has to do things that are only in your best interest. But nonetheless, they kind of have their hands in the cookie jar. So that fear of misusing is one of the reasons people are reluctant to grant certain powers. And the other is just simply a lack of trust. So it's those people who say, yeah, I'm going to appoint my son, but he's had his ups and downs, and sometimes he does really responsible things, but he has a history of making some stupid mistakes. So sometimes people have that lack of trust, so they're very particular about what powers they want to grant that agent in their power of attorney. So you always want to make sure that you consider that level of trust and that financial savviness of your power of attorney agent and alternate agent that you recommend. Some people say, I want to treat my children equally, so let's give them all this power, even though you know that one may do a better job than the other. So it's always important that you appoint the right people, regardless of the fact that someone's feelings may get hurt because they weren't the right person and you didn't appoint them as the agent on your power of attorney. Okay, hope that helps. We'll see you next time.